seats, we are going to get started. We have a panelist who we know is here. We're going to find him out in the hallway. I want to just add my welcome to everybody and thank you so much. I'm Julie Nice. I'm on the faculty here, delighted to have joined this law school a few years ago. I think that I must simply remark that I believe we have just experienced the real benefits of diversity in action. Here we are, a diverse community of people with diverse backgrounds and experiences, having a much more robust conversation because of that diversity, and I think that is something that should not go without acknowledgement. I want to thank the speakers of the first panel for providing such fantastic overview for us, from Chancellor Cantor at both the benefits in the abstract conceptual sense and also the socioeconomic data, and Mr. Purdy defending the so-called colorblind approach, and Mr. Mellon really showing us how it's working on the ground. If time allows, today, I'll speak a little bit more about the current move towards socioeconomic status and how that relates to race. But we've seen already a lot of the interesting mechanisms that are at work today on diversity issues. I think we're all trying to figure out how do we open the pathways to leadership for all. And we know it involves opening minds and hearts and not blinking reality of residential segregation, unequal schools, huge achievement gaps that are persistent, the privilege and preference of social capital, and racial and family legacies, and the ever so persistent stereotypes and prejudices. So we're here to discuss all those issues, and we're very glad to have kicked it off so wonderfully with the first panel under the leadership of our very own and beloved John Adler. So without further ado, to our second panel, we are going to speak a little bit about affirmative action beyond the classroom from various perspectives, and I think you'll enjoy each of these and what they add to the conversation. Connie de la Vega is one of my colleagues here who herself has written numerous briefs about international human rights and the way that relates specifically to race and gender and civil rights for youth, et cetera, in our criminal justice system, and has been cited by the United States Supreme Court. And we are delighted to have her here giving us an international human rights perspective. We have as well Lindbergh Porter, who is here from Little Mendelssohn, and who will talk about his work and his clients' work seeking to have inclusion in the private sector. Dan Siegel, a partner at Siegel & Yee, who has done work on really pushing issues within the faculty and athletic and Title IX educational context once inside the university system. And Robert Zelnick, a well-established journalist and professor at Boston University, who will bring his perspective as well with some of the critiques of affirmative action. So as I said, if time allows, I will also make some further remarks, but I'm very mindful of how much we went over the first time, and I want to give our guests here time to respond. So we will begin with Professor de la Vega.
Thank you, Julie, and I want to thank the students for organizing this all-day event. It's a great discussion to be having at this point. I'm going to focus on two treaties that the United States is party to that not only specifically prohibit discrimination, but also require affirmative action to address de facto discrimination or inequality. They also cover a broad range of categories of protected groups that would benefit from affirmative action beyond the ones that we're used to talking about under the cases that have been discussed in relation to employment and education, as well as rights that go beyond employment and education, so I will try to get to those. And if I have time at the end, I'll just briefly mention how this international law can be used, and you do, as part of the materials, have a brief that I filed in the Fisher case as an example of how this law can be used to one way the law can be used. There's other ways it can be used, and I try to touch on that. So the first treaty that we're party to that's probably the most important in relation to this topic is the International Convention on the Elimination of Race Discrimination, or CERD, which the U.S. ratified in 1994. So we've been party to this almost 20 years at this point. It prohibits discrimination on the basis of race, color, descent, or national or ethnic origin. So those are slightly broader than what we're used to thinking about under our Constitution. And in the first article, it not only prohibits discrimination based on those categories, but also says that special measures taken for the advancement of racial or ethnic groups to ensure equality or exercising rights are not deemed to be racial discrimination. So the thought that taking measures to achieve equality is discrimination is specifically rejected there. In Article 2, the treaty specifically mandates that special and concrete measures are required to guarantee full and equal enjoyment of rights for certain racial groups. So I'll just leave it that treaty there for at this moment. The other treaty that we're party to that requires special, they call it slightly different, remedial measures, is the International Covenant on Civil and Political Rights, or the Iccpr, as I might refer to it while I'm talking. And that provides that all rights in that treaty are to be provided without distinction of any kind, such as, and I'm going to list all the categories, race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. That list is pretty broad and probably can be used to address discrimination, any kind of arbitrary discrimination based on various categories. And I'll mention a few later on that come up under that treaty. Again, this treaty provides no arbitrary discrimination based on a group, and the obligation to adopt legislation or other measures to give effect to the rights in the covenant. Because the United States is a party to the treaty, it has been reviewed by the committee that reviews each treaty and has made specific comments about the United States in relation to how it's meeting its obligations under the treaty. In 2007, the third committee cited race-conscious educational admission policies and scholarships as evidence of United States compliance with CERD and referred to the Grutter case as a positive example of what the United States was doing in relation to that treaty. But it also said that the U.S. has not done enough to enact special measures to eradicate de facto discrimination in schools. This particular treaty the U.S. will be reviewed by this treaty body again next year, so they will be updating what has happened since 2007 when they review the United States next year. In 2006, the Human Rights Committee, the body that oversees the Iccpr, recommended that the U.S. take remedial steps to address racial discrimination in schools. That treaty body is going to be reviewing the United States this year, and there's already reports being filed with respect to various of these issues. And again, the treaty body will follow up on what its recommendations were from 2006. The CERD requirements the treaty itself does not require a finding of purposeful discrimination, only discriminatory effects in order for those requirements to kick in as far as the special measures that it mandates. Because these treaties cover a number of rights, these measures could be used or be required in a number of situations. For example, the death penalty, its impact on minorities might be addressed through these treaties, and maybe there need to be special measures to address the fact that more minorities are subject to the death penalty than other groups. This could also happen in relation to deprivation of liberty and any arrest-related type activity. Criminal due process, there's sometimes issues about equal treatment before tribunals, so that could come up. Privacy, family, and home are rights covered by these treaties, which again would be subject to these mandates. freedom of expression and peaceful assembly, protection of children, equal protection of the law, the right to vote. We've seen a number of attempts to try to limit the right to vote with an impact on minorities. That the treaty actually could be very relevant to those particular efforts to at least try to stop those, at least prevent those efforts, which so far the courts have done. One issue that hasn't been addressed directly is the right to marriage is mentioned in the treaty, and the choice of spouse. In third, Article 5 specifically mentions that without saying the right to marry is between a man and a woman, which the Iccpr does. Third just says you've got a right to marriage, that there should be equality in the right to marriage and the choice of spouse. So that would be another issue that could be used to, that special measures could be used to address. Right to work, right to housing, access to place or services intended for use by the general public, such as transport, hotels, restaurants, cafes, theaters, and parks. All those would be measures that could be used to address any de facto discrimination, not that we have intentional discrimination, at least on the books anymore. The other thing that the treaty requires are measures to view, with the view of dealing with combating prejudices. So some of the issues regarding bias that still exist in various contexts, the United States has an obligation to take measures to combat prejudices in those contexts. I think I have a few minutes left to talk about how to use these treaties in United States courts. The first issue that comes up with using these treaties in U.S. courts is that the United States ratify them with a non-self-executing declaration, which makes it difficult to use the case as a basis for filing a lawsuit, and the language that the United States used when it attached these declarations to the treaty said that they were trying to say that there was no private cause of action to base these treaties on. So that basically they're saying they don't want a bunch of lawsuits because we ratify these treaties. However, I have argued, and I've written a few articles, and I've actually argued in some of the briefs, that a private cause of action is different than using it defensively. So, and what I mean by defensively is if a university or an employer want to enact special measures to promote equality, that they should use the treaty and say, we're trying to comply with our treaty obligations. And that is what I argued to the U.S. Supreme Court that the state of Texas was doing, was upholding our treaty obligations. It would be better if the state of Texas actually said it was doing that, because then they would pay more attention. But Justice Ginsburg has been interested in the past in both these treaties and has mentioned them in Grutter. A third way, which is probably the easiest way to use these treaties, is to use them to help as an interpretive guide to the courts. The U.S. Supreme Court has specifically mentioned that international law is relevant to our constitutional analysis, and that these provisions, these provisions, as well as some of the practice in other countries, which I did address in the brief but won't go into, would be relevant to the court's analysis of various measures that states or private people could take to promote equality under these treaties. So I'm going to leave it at that. I think I stuck to my time. And thank you very much. And again, thank you. I thank the students for holding this symposium.
I'll have my drink of water before I start speaking. What do you say, the drink of water when?
Before he starts speaking.
Good morning. Good morning to all of you. I will spend just a few minutes talking about what private employers are doing, but I would call to your attention, particularly those of you who are still students, to the United States Steelworkers case, and Weber, and ask you to trace that line of cases through the more recent cases in the United States Supreme Court dealing with voluntary affirmative action plans in the private setting. And I think you'll get a sense of what the court has continued to think about voluntary affirmative action plans, and the court has been less hostile to voluntary private affirmative action plans and efforts to continue to desegregate the workplace than it has recently been to efforts in law schools and in universities to continue to desegregate law schools and universities. And employers in that context have evolved from desegregation of workplaces to some integration of workplaces, and I do make a distinction in those two, to affirmative action plans in the late 70s and early 80s, to the 90s, diversity, and then to more recently, 21st century diversity and inclusion in efforts to continue to make workplaces different than they were in the last century. Businesses strive for diverse workforces, but are challenged by legal hiring constraints of Title VII, as you know. No court has yet recognized workplace diversity as a goal that trumps Title VII's prohibition against reverse discrimination in employment. In no case has an employer presented evidence of the affirmative benefits of workplace diversity. And researchers lack the data required to comprehensively study diverse workplaces and the workplace impacts. That is the challenge and the cutting edge for employers at this point. And I'm happy to tell you that certain employer groups are beginning to assemble the resources necessary to do that and to participate with, of all places, the University of Texas. My law firm has offices in Texas, and we are the private employer component of that to develop that effort for private employers, and you'll be hearing more about that. Let me, in the few minutes that I have left, though, turn to something that perhaps is more contemporary, meaning contemporary within the last 2 hours. This is February, Black History Month. My favorite person from the 1800s, Frederick Douglass, was born in February 1818. He thinks it was February 1818. He's not entirely certain, as you know, for reasons that you know. I am very happy to be on this panel, somewhat by accident, and by invitation of Dean Brand, who called me a couple of weeks ago to ask me, and I'm not an academic, but I would have come to sit in the audience, but I find myself on the panel. And I have to think of Dean Brand as the other members of the panel that Frederick Douglass found himself on in 1841, after he had escaped slavery and made his way north, found himself at a meeting of the abolitionists and was asked to speak. The abolitionists at the time being William Coffin and William Lord Garrison. And so Dean Brand is the abolitionist of our time. The abolitionist to remove all of the badges and incidents of slavery that continue to be present. And so I say to the University of San Francisco, the University of Michigan, the University of Texas, thank God for you. Thank God that the University of San Francisco Law School has often debated, but never abated, and never abridged programs that find, recruits, and indeed admits students like me from Holmes County, Mississippi. You saw on one of the earlier slides in the earlier panel the case Alexander versus Holmes County School Board. That's the county that I come from. When John F. Kennedy used the term affirmative action in 1961 in Executive Order 10925, I was 11 years old growing up in Mississippi. It established ultimately the Equal Employment Opportunity Commission and the Office of Federal Contractor Compliance in later years. Let me tell you that the affirmative action used by Kennedy in that executive order, in fact, changed the status quo. It did not maintain the status quo. It was not Kennedy's objective, and perhaps not even his preference, to change things as they did. But take it from me, it changed things for black folk. And then in 1964 and 65, when Johnson, Lyndon Baines Johnson, then president, signed the amended executive order to become 11246 in the summer of 1965. Keep in mind that he signed the order in September of 1965. Johnson made the commencement speech at Howard University in June of 1965. And Johnson made clear that affirmative action meant more than maintaining the status quo, meant more than non-discrimination, as has been suggested earlier. Let me just read to you Johnson's words. Nothing is more freighted with meaning for our own destiny than the revolution of the Negro American. In far too many ways, American Negroes have been another nation, deprived of freedom, crippled by hatred, the doors of opportunity closed to hope. But freedom is not enough. You do not wipe away the scars of century by saying, now you are free to go where you want and to do as you desire and choose the leaders you please. You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of race, and then say, you are free to compete with all others, and still justly believe that you have been completely fair. This is the next and more profound stage of the battle for civil rights. We seek not just freedom, but opportunity. We seek not just legal equity, but human ability, not just equality as a right and a theory, but equality as a fact and equality as a result. To this end, equal opportunity is essential, but not enough. Not enough. Men and women of all races are born with the same range of abilities. But ability is not just the product of birth. Ability is stretched or stunted by the family that you live with, by the neighborhood you live in, by the schools you go to, and the poverty or richness of your surroundings. It is a product of 100 unseen forces playing upon little infant, the child, and the man. That's in 1965. Just 3 weeks ago, the Equality and Excellence Commission issued its report Februari 2, 2013. The Equality and Excellence Commission is a federal advisory committee chartered by Congress and operating under the Federal Advisory Act. And you can look it up. Edley from Berkeley, a professor from Stanford, and someone from the Hoover Institute are among its members. Let me just read its findings. While some young Americans, most of them white and affluent, are getting a truly world-class education, those who attend schools in high-poverty neighborhoods are getting an education that more closely approximates schools in the developing nations. In reading, for example, although U.S. children in low-poverty schools rank at the top of the world, those in our highest poverty schools are performing on par with children in the world's lowest achieving countries. While the highest poverty rate in the developed world, amplified by inadequate education received by many children in low-income schools, the United States is threatening its own future. He goes on to talk about the same kinds of things that Lyndon Johnson talked about in 1965, ultimately including we cannot have a strong democracy without an informed, engaged citizenry. As I heard Manny say a little bit earlier, am the product of the special admissions program here at the University of San Francisco Law School in 1978. Having been a similar recipient of an affirmative action plan at the University of Illinois 10 years earlier in 1968. In 1978, I was admitted to school here. In 1988, I was elected a partner in what is now a 1,000-person international law firm. 10 years later, in 1998, I became president of the Bar Association of San Francisco. 11 years later, I would argue for the third time a precedent-setting court in the Ninth Circuit or the California Court of Appeals setting. Last year, I had the honor of being selected Alumni of the Year by this law school. So when we talk about the subjects that we are dealing with here today, I have this urgency, this sense of urgency to make it real to you. That lives are affected and lives are changed by what we do and by what the Supreme Court does. It is beyond mere academic for those of us who are affected. I am not alone in this. I know that one case doesn't prove anything. I'm a trial lawyer and I know evidence well. But I do tell you that there are examples of success and examples of what we're trying to accomplish here, and that these decisions, these discussions are important to inform us more broadly about the impact of the efforts that we are undertaking and about the importance to the nation, of what we're doing. I do apologize again. I know this is an academic conference and an academic discussion, but I thought that if there is some role for me under these circumstances, I'd better spend my time telling you what I have told you. Thank you.
I guess it's now the afternoon. Good afternoon. I want to thank the organizers of the symposium, Dean Brand, and I want to thank my friend Matty Fortin for helping take some of the pressure off that I was feeling after the end of the last panel. I want to start by talking a little bit about the context of this conversation and then move into what I think are some practical approaches we can take in the law to advance the cause of diversity regardless of what the Supreme Court does in the next couple of weeks. But to me, the lesson of 66 years of life is to get to have an appreciation of history. And the reason I say that is because I very firmly believe that race matters because history matters. Some of us have ancestors who came over on the Mayflower. Some of our ancestors came over on the Middle Passage. And that makes a big difference. We live in a society that's not even had a pretense of equality for people of different races for 100 years, and that's generous. Maybe 60 years is a more accurate statement of that. And the point on that is that remediation for centuries of discrimination and oppression does not equal a racial preference for a person of color whose background has not put him or her at the same starting line. And I think it should be obvious that a big-time college basketball team is not a freshman entering class. You know? There are really different sides to this debate. When I listened to Chancellor Cantor, I really felt elevated. I felt that the voice of the Enlightenment that's been part of our history for the last 200 or 300 years is still with us, and that there is a vision of a society of liberal democracy, a society where a rising tide lifts all ships. But I'm reminded at the same time, and this is something I want to stress, is that we don't all share this same worldview. And in fact, the leaders of our society don't share the same worldview. When the Supreme Court comes down with whatever decision it makes at Fisher, we'll have to firmly keep in mind the decision in Bush versus Gore, the decision in Citizens United, the upcoming decision on whether we even need the Voting Rights Act anymore in the United States. And these folks aren't on the same team as I am. I don't know about the rest of you, but we really have a different view. I spent 8 years on the Oakland School Board. And let me tell you, that was probably the most frustrating and disappointing experience of my life, seeing what Professor Adler experienced in New Jersey. This is an urban school. It's not Jefferson County, Kentucky. It's right across the bay, where over 60% of the children do not graduate from high school. It's an urban school district where over 80% of the students qualify for the free and reduced lunch program. It is a school that is made up primarily of low-income African American and Hispanic students. And I would submit to you that it's not an accident in our society that California, which spends one of the least portions of its income on public education, is a state in which the vast majority of students look like the kids in Oakland. They're from low-income African American and Hispanic backgrounds. So we're clearly not on the same team, and we're not in a situation where simply pretending that we are and that everyone goes up to the starting line in the race with the same advantage and the same privilege. And we've got a lot more to do, and we have to do it drastically. If we do it individual by individual, we'll be having these conversations, or someone will be having these conversations 100 or 200 years from now. And hopefully that's not an acceptable model for you. So that's a little context. What I was, I think, asked to speak about are some of the possible strategies that we could employ to create a more just and diversified student body at our colleges and universities, regardless of what happens in Fisher. So I want to talk about two areas briefly that I've practiced in over the last 20 years or so. One of them having to do with diversifying faculty, because the notion is that the extent to which a faculty is more diversified, in other words, the extent to which a faculty is no longer dominated by white males, then it can happen that a student body will be more diversified. So Ann Wiles, who's my partner in many ways, and I brought a case against the University of California, which was resolved in 1993, called Harrison versus the Regents. And very briefly, we found ourselves litigating with respect to a mathematics department that is, by any estimate, one of the top 2 or 3 in the United States, and which had never been very welcoming to women faculty members. In fact, despite the fact that it's a big department with 40 or so tenured professors, there had only been 2 women in that department ever who attained tenure, and one of them attained tenure in the department only after she was promoted from instructor, after she was elected to the National Academy of Sciences, and the New York Times called the chancellor and asked a question about Professor, I can't think of her name right now, and the response was, we don't have any professor by that name. And subsequently she got tenure. But the point was that women in particular are still incredibly underrepresented in mathematics and science and engineering and so on. And of course, it's a self-perpetuating process because if there are no women faculty members, there are very few women students. And Jenny Harrison was told as a young person growing up in Alabama that her talents would probably be better suited to a career in music. And she pursued that for a minute and then decided to go into math. Well, long story short, we won this case, and she obtained tenure. Chancellor Chien, who in a moment of enlightenment at UC Berkeley ran the campus, not only promoted her to tenure, but promoted her to full professor. And the outcome of that, or one of the outcomes, is that there are now a lot of women in the graduate program in mathematics at UC Berkeley. And for those of you who are interested in pursuing this field, we're all familiar with the McDonnell Douglas versus Green test, which in the college or university tenure situation basically requires a court with the help of experts to compare the tenure files of people denied tenure with the tenure files of people who have been granted tenure. And this has been a vehicle not only for increasing women's participation at the university level, but also the participation of people of color. There's a very important California case which kind of lays out the process, the standards, and the burden shifting called Clark versus Claremont Colleges, which involved an African-American professor who ultimately was tenured there, and is currently kind of an interesting case. And it just has to shock you to say this and to hear it. We've been representing an African-American, extremely qualified, extremely bright guy, denied tenure at USC Business School. There's never been a tenured faculty of African-American descent at USC Business School. And you have to ask yourself, why is that? And we know the reason. So the point being, though, that if we can fight to increase diversity on faculties, that faculties will recruit and increase diversity in the student body. The other thing I wanted to talk about in the same context is Title IX and Title VI. And I was happy that Mr. Purdy put Title VI up on the board before, because Title VI is kind of like the ignored stepchild of Title IX. And Title IX itself has gotten a lot of interest, but in only a small part of its applicability. I mean, you ask most people, they think, well, what's Title IX about? Title IX is about having women allowed to participate on athletic teams. But Title IX, which was adopted in 1972, says much more than that. It says no educational institution which gets federal funds may deny opportunities to women, period. And Title VI, which is older and again less utilized, says the same thing about race and ethnicity. So you get around a lot of issues. You have a set of legal principles that are based on the spending clause of the Constitution, and the notion is if you take the government's money, you have to follow the rules. And in the Title IX context, the conversation on athletic teams, and the reason I bring it up is to get especially the smart law students here thinking about other possibilities. It says you have to have equality with respect to opportunity, funding, and services. Okay, so we understand what that means in the athletic situation, but some of the implications is that if the school is under those Title IX requirements, then it may be motivated to go out and recruit students so that it can meet the requirements. I mean, you can't have equality of funding and opportunity on your athletic team if you don't have athletes. But Title IX goes far beyond athletics. It goes into any educational training program. We brought a successful suit a couple of years ago, very successful actually, involved the Fresno Fire Department. And we argued that it was subject to Title IX because they got federal money for a training program. So they had to follow Title IX's dictates. Now, think about Title VI and think about the same kinds of arguments that you could make with respect to race or ethnicity. We could, if we decided to, especially now with the present administration, which seems a little bit friendlier to these ideas than some recent ones, argue that the Department of Education needs to get much more active in terms of its rulemaking with respect to Title VI. It needs to enact regulations ensuring that educational institutions increase their participation of people of color, particularly African Americans, because they get the federal funds, not only in numbers, but in funding and in services. And that will increase the motivation for institutions which get these federal funds to figure out ways to bring students in, to bring in a more diverse student body. And, you know, we don't have to be too cute about it to understand that you can increase your attendance and participation by people who have been shut out of the system without enacting specific racial quotas. You don't have to go out and say, well, we're going to have 10% this or 15% that, but you can adopt admissions criteria which have the same result. And as Lindbergh was talking about, you know, particularly in the context of private employment, people do figure these things out. So I want to finish with that. I want to urge, again, particularly the students who are interested in this field, to think about the creative use of the legal tools that we have available to meet the need of creating a diverse society. Thank you.
I do not classify myself as a extreme conservative or reactionary, or one who is insensitive to human rights or political rights. I spent, in terms of background, I'm writing my memoirs now. I spent 21 years at ABC, having had the privilege of being arrested by the Russians in Moscow. That's like the scene from The Manchurian Candidate, isn't it? Next thing I know, Frank Sinatra will be shooting at me. And when I covered Israel, part of my beat was going into Jordan from time to time. And sorry to say, the king didn't like me for a while, and I was barred from entering the city of Amman. So it's been a diversified, covered Israel where I was warned not to write anything about a big spy scandal they had over there involving an American Jewish espionage agent for Israel. So I'm familiar with tough situations, and I've learned to appreciate the context in which they occur and to try to make things better as best I can. It's not always a total victory. Sometimes you have to take 2 steps back to gain 3 steps forward. It's often worth it. For example, the first of the 2 Gavel Awards that I won from the American Bar Association was for a series of articles I did on justice in the Alaskan bush. Before that time, this was in '68, there had been almost no recognition of the fact that actual human beings lived in the Alaska bush. And they had needs, they had political needs, they had medical needs, they had social needs, they had all kinds of needs that where the first step was simply recognizing who they were and where they were and why they were there. I had the privilege of doing the Nixon interviews. I was executive editor for David Frost, and it took patience to build a case against Nixon, and to build it so convincingly that at the end he was articulating his own sins and the reasons why he let the country down and probably deserved the withdrawal from the presidency that he suffered. And the same feeling as I was listening to the talks here today by people who are eloquent, passionate, forward-thinking, and deserve to be listened to and respected. And I can assure you I feel that way about them. At the same time, I regard it, maybe I'm too much of an optimist in some ways, but I regard the steps that this country has taken in my lifetime as heroic in the area of civil rights. When you think of what the South was, when you think what the blacks who migrated to the North experienced in places like Detroit, when you remember the Emmett Till case, you almost have to pinch yourself to realize that in the entire civil rights movement in this country, with the mammoth change that occurred, there were fewer than 100 deaths. Now, one death would have been too much. And I'm not saying it as a tribute to anybody who was involved in violence, but by and large, this country chose to undergo peaceful change where the leading institution was not a congressman, was not a president, but was 9 justices from the United States Supreme Court. By the same token, we look around today, and I'm not going to repeat the facts and figures that were presented here. I think they're relevant. I think they're important. But we must also remember that we live in a complex society where commitment to civil rights, a commitment to improvement of one race or another race, has to be done with the context of the battle kept in mind. Now, there's been a distinguished African-American sociologist, for example, who wrote about the fact that over time, many blacks, including black preachers and black teachers, left the inner cities where they had functioned and had done their best to keep the spirit of their people up and help some areas in terms of being more law-abiding. If the infrastructure of society leaves a particular area, you can bet your bottom dollar, no matter whether that area is populated by blacks, whites, Indian Americans, First Americans, that there is going to be a void, a vacuum that will be filled by more undesirable elements and a way of life that was at least marginally acceptable and had its bright spots becomes something else, something entirely different. Becomes more like the terrible places we hear about and see on television. That's certainly one complexity. The world is full of complexities like that. I would look at the Supreme Court starting in 1954, and my conclusion would be that it has presided over the most fantastic series of changes that one can hope for in a democracy. And I'm not simply talking about race relations. Gideon v. Wainwright, titling everyone accused of crime to the right of counsel. The Miranda warning that I hear in my house 57 times a night because my wife likes police shows. The freedom of religion that received positive reinforcement from the courts in cases where people were allowed not to participate, which in some ways is as great and precious a right as the right to participate. I think a person who had been in some remote place, lost to civilization, who reappeared after 20 or 30 years, would think we had done one hell of a good job, and I feel the same way about this country. We talk about excesses by the military here or there. Go back to 1940 and see what the world was like, poised with a possible takeover by Hitler and Stalin. Who prevented that? Which country prevented that? Which country then used its resources to rebuild not only the democracies, but even make offices of rehabilitation to some of the less desirable countries in the world? I say all this, and I really should bring one other factor when I was talking about civil rights. There's a book, and admittedly it's controversial. Not everybody would agree with it, called Mismatch, by Richard Sander and Stuart Taylor. Taylor's the editor of that legal newspaper. Sanders at UCLA. What they did was take what is known, and I'm sure known to you, as a longitudinal survey. They followed the same group of people over many, many years. In this case, they concentrated on African American law students. And they compared two types of students. The one, they had identical grades, identical qualifications, and they both received invitations to attend a good law school. The one, although a good law school, but which was a reach for both of them in terms of their academic credentials. Student A chose to accept the affirmative action package. Student B chose a law school that was more conversant with his documented academic talents. And sure enough, after 4 years, they found that the student who had selected the more modest school had better grades, students like him, fewer dropouts, more passed the bar exam, more landed with the law firm of their choice. Is that an argument for abandoning certain forms of affirmative action? I would argue not standing alone, but if the evidence comes in that this is in fact the case, I would say we have to consider it. We have to consider whether affirmative action as it had developed is the right ticket to progress in all areas. I deeply appreciate the opportunity just to mention a couple of these things. As I think I mentioned at the beginning, I'm in the process of writing my own memoirs. More often than not, I've ended up on the liberal side of issues. And I can really say that it's been a journey of love and reward and satisfaction. I wouldn't have traded it for the law degree that I stuffed away in my pocket at one point. And audiences like this and others that I've had the privilege of addressing make it all the more sweet. So thank you very much. That's all right. If it's warm tomorrow, I'm playing golf.
Kelly. We've had several events here at the law school on Fisher and on affirmative action, so I know there are a lot of students who have thought a lot about this, and the students in one of my classes actually read almost all the amicus briefs that were filed by various organizations for the United States Supreme Court. So I know that you're probably eager to speak, but I have a few things I need to say. It seems to me just very broadly that, again, as I said in introducing the panel, it seems to me that we are seeing the benefits of diversity in action when we can bring together, as we have today, people of diverse backgrounds, experiences, and perspectives to have a more robust debate. And I think that that's really the primary takeaway. But in law in particular, it is our charge to think about these things all the time. And it seems to me that the other major issue the lesson, and that's another takeaway here, is that justice is always contextual. We are having a conversation in the briefs on the social science evidence about what do we know from society? What do we know about how race matters? What would it be like to live in a world where race doesn't matter? I have no idea, right? And would that be a desirable world? How can we possibly know? We are so far from that. We see race consciousness all around us. And I think, to a certain extent, Manny's remarks at the end of the last session really pointed this out. We have to keep in mind we are not talking only about eliminating systemic disadvantage, but we are also talking about all the ways that people, myself, in many respects, others, we walk around with completely arbitrary advantage that we did nothing to individually earn or deserve. And I think we focus far too often on the disadvantaged side. And insofar as it's a zero-sum game in society where we're trying to get ahead of others, we have to remember that it's not just disadvantage but advantage that we're talking about. That said, I do appreciate Professor Zelnick's optimism about how far the United States has come as a culture. And we've heard Mr. Porter powerfully here raising the life example of Frederick Douglass and so many others brought into the room and their legacies brought into the room for various purposes here today. But it does seem to me that at the end of the day, we're talking in the United States in the conversation about race, not just about non-discrimination, but indeed about the historical context and our current social context and what we are doing. What are our ends? Chancellor Cantor in the first panel really walked us through why diversity is a compelling end. And in the law, it's almost just unimaginable that we could get a Supreme Court decision this term that would make a broad pronouncement that trying to achieve diversity in higher education is not even a compelling government interest. It's possible, but it just seems, it seems it would be such an incredible about turn with so much of the social context still unremedied. So it seems again that we're going to come down to means. And for those of us who've been talking about this all semester, that's not too surprising. What are our ends are one thing, but we're having a debate here in the law and in social science about the means. What's the best way to achieve justice with regard to race? Is it that we should seek assimilation, or do we have to dismantle subordination to get to where we're going? Can we only be backward looking, or can we also, and should we also, look forward? Do we only try to remedy things that are intentional that cause harm, or do we also look at the effects, right? Do we only look at government actions that are facial about race, or also do we look and take into account a disparate impact? And Mr. Siegel powerfully pointed out many of our important civil rights statutes that actually talk about disparate impact and allow us to grapple with disparate impact and don't do what the Constitution irrationally does, which is to limit us to intent only. And then finally, in Professor De La Vega's remarks, the international law treaties, the idea in international human rights that one would only look at facially intentional government discrimination as what human rights is all about would have been such an impoverished sort of view. Instead, the treaties really invite us and require us to look at effects. So that brings me to just one final thing, and I want to come back again to the example that was given in the first panel by Mr. Mellon and the Louisville litigation. Because at the end of the day, one of the things Professor Zelnick raised Richard Sanders' work in the mismatch theory, which is out there. There is I'll simply say there is a voluminous amount of social science as well as legal scholarship that vigorously criticizes the lack of conceptual clarity, the lack of generalizability, the lack of validity, and the lack of reliability, and I said all that, and I'm not a social scientist, so that was a feat right there, of Professor Sanders' work. And Professor Richard Lempert at the University of Michigan Law School, who's a prominent social scientist, has been one of the leading voices in that. Most recently, in defense of the turn, his attack on a race-based affirmative action, Richard Sanders has recently been pushing a socioeconomic-based or a class-based affirmative action. And there's a recent pushback on that. As someone who, in my own work, has devoted myself to studying the intersections of these disadvantaged aspects of our lives, arbitrary disadvantage, it seems to me particularly pernicious to pit class against race. When in fact what they do is operate in such powerful interlocking ways to really create overclasses and underclasses that have nothing to do with individual merit. So I would add that, and I think the reason I said I was going to come back to Mr. Mellon's point and the Louisville example is what we saw there. I'm not a social scientist, so as soon as I start seeing those percentages, I think, okay, how's this playing out? That sounds very numerical and mechanical, where you're considering, you remember from the Louisville example, in their new approach, they're considering a blend of family income and race and educational attainment to try to figure out where that interlocking disadvantage might be. And what I think is very interesting and powerful about that, and one of the places it could take us, is to the possibility of finally stopping the real nonsense on identity politics and the way it plays out in our political discourse and in law, which is to see just one little trait of a person at a time, completely disconnected from the person's lived experience as a whole human being, where we all have aspects of our race and our sex and our class and our sexuality and our age and our family's educational attainment, et cetera, all playing together in our own little chemical recipes here as we walk around the world. But taking a more intersectional approach and thinking beyond these just very, again, impoverished sort of views of what human identity is like is something that seems to me has got to be the next challenge for law. It's hard for us because we classify one thing at a time in a linear way. And those of us who go into law school and stay in law are often very comfortable with those systems. But life is more complex than that, and we've got to get more holistic than that. And I thought that the Louisville example was a really interesting example of how to do that in a working, practical reality. And I hope that, especially for the students out there who've been thinking about this from your various perspectives of what your goals are, you'll think of more creative means for us to get to what would be meaningful, contextual justice. So I offer those remarks, and I open it now to other questions and comments from the audience. Please.
Oh, yeah. In this morning's Chronicle, did you say that Women Make History has a documentary which will be on CBS?
Oh, I thought I was really loud. Yeah, at 8 o'clock this coming Tuesday on PBS, and so we need equal opportunity for women, too.
Yes, we do. Other questions, comments? Yes, please.
If the Supreme Court should disallow a race preference, it perhaps would not be as awesome as you think, because the first time they considered this issue in the Bakke case, 4 justices said, look, the 64 Act, Title VI, prohibits race discrimination by a school that receives federal funds. The school receives federal funds and racially discriminates, therefore it's illegal. And you don't have to consider the Constitution. If one more justice had joined that, Powell disagreed with the other 4 and took this peculiar position all by himself on diversity. But if he had joined the other 4, that would have been the end of affirmative action right then. So it would hardly be very dramatic to say, well, we're going to, in fact, enforce Title VI now. But more importantly, I think you're setting the issue in much too broad a context, the whole questions of race in America. The issue here is, should educational institutions give preference on the basis of race? Now, once we're talking about that, we try to hide that by definition or anything else, you're evading the question. The reality is that in order to get greater minorities, primarily blacks, into selective institutions, they use different standards, somewhat lower, giving preference on the basis. Now, that's the issue. Is that a good thing to do? It's going to have various costs that have been discussed, and hopefully various advantages. But there's no reason to think about it like we're talking about race in general. The issue is that a sensible social policy? Is really the only thing we're talking about here.
I do want to respond. I just completely disagree. That's not what Grutter says. I mean, Grutter says race is part of your life and your identity, and it's part of the file, and you'll be holistically evaluated. And so far, those means have not been overturned by the United States Supreme Court. There is nothing about preference in the University of Michigan Law School policy that was upheld by the United States Supreme Court. So I just simply disagree.
Could I say a word also? You know, I think the problem with your question is its assumptions. Its assumptions are that someone's score on a test reflects their qualifications to do something. So if you admit someone whose score is 89 versus someone whose score is 93, you're lowering the standards. I think what a lot of people are saying, including a lot of the people on these panels today, is that those standards are not sufficient for making discriminatory decisions. And that if we're going to create a colorblind society, we have to use decision-making standards that take into account people's different backgrounds and histories. But once you say you're lowering standards, you've essentially, argued the point and won it.
You're evading what this is about, unless you say, now maybe these standards are not valid. Maybe we should have other standards of various sorts. But there is no issue here. Larry spoke today about affirmative action means equal opportunity.
notion of consideration and consciousness of an aspect of one's identity is to you, if I understand your remarks, and I appreciate them, and we'll move to the next question behind you.
Whether that's permissible.
No, the issue is whether that is in fact a preferential treatment, right? And that's Mr. Siegel's response to you is that, that he does not agree with you about that, and I think that many people who read the decision, first of all, don't read it that way. But that's a debate that we're having, so let's let other people into it. There's a hand back here. Cantor, did you want to?
I was simply going to say, I think it's caricaturing both admissions processes as they exist every day in every institution I at least have ever been involved with and all those I've led. And certainly what was stated in these two cases, both the Black case and the Beard case. In no instance in either of those admission processes was an assumption about race the only factor involved. Whether you took what was viewed as not narrowly tailored and breadth, we had a point system that had many different dimensions involved, not just race. And in Wood, we certainly had a holistic evaluation system. So you've got to be really careful when you reduce these cases to being issues of yes or no based on test scores and race.
Let's let some of the other audience members in.
There would have been no case.
Well, let's let some of the audience members in, please, Cassandra.
Thank you, Professor Nice, and to all of the panelists. I'm a third-year law student here, and proud to say that I am also a product of affirmative action. I am a female who came from very poor socioeconomic status, and in my mind, I could not see a more holistic approach to applications process in higher education than the one that is used by University of Texas. And that is at issue before the court in the Fisher case. And I posed this question to Professor Nice and Professor Adler at a different panel, but I'll pose it to these panelists here and to the audience kind of as a thinking exercise. What do we envision as a colorblind applications process? Is it honestly removing the race section from that first portion that we all fill out, where you now can mark no preference as to your own race, and then have someone try to completely remove from their application something that is incredibly important to each and every one of us from the day that we're born, and that's our race. I honestly cannot envision such a system, and I pose it to the audience, how you remove race as a consideration. Is it simply really saying that we're not considering race, but it's there?
Why is it so hard? I mean, it's not technically difficult. There are races, there are things you blot out. You're arguing that it should or shouldn't be considered. That's a policy question. If it's a policy question, it can be executed like thousands of other policies that we have in the country, ranging from race to tax returns. I don't see.
Yeah, I just respond to that point and to the question that's being pressed. Are we talking about race and race discrimination? The reality is it may be a policy question, but it's a policy question for the country. And to follow up on the point made earlier about what this country is or is not, or what it stands for, or hopes to achieve, or what its aspirations are, the reality is this. For people who are not white and are not white male, who stand on one side, the line, it is unacceptable to be excluded. And to put it bluntly, if affirmative action is discriminatory, then it is a better form of discrimination for those of us standing on the one side of the line than standing on the other side. So you cannot have a society that we aspire to have unless we address and redress these issues. there is no peace until there is justice.
I agree with that. Discrimination intended to include is a different thing from discrimination meant to exclude. When people say, you heard me say, we're discussing this in terms of what brown means. Did brown, the moderator also said, did brown mean, it's the debate, did brown mean no discrimination, or did brown mean that you must do what you can to further racial equality? What does it mean? And the answer is, Brown didn't speak to this issue. That is, you can't, the pretense that we're going to decide whether or not race preference in college admission is permissible on the basis of Brown is not realistic. Brown certainly had nothing to do, was that an issue in the case? Of course not. So legal terms, couldn't bear upon it. So the issue is it good social policy to do that? We won't decide it by Brown, and I agree that you can't just say, well, race discrimination is bad, and therefore this is bad. I wouldn't say that. So this is quite different. It is race discrimination. As race is being taken into account. We don't want to just change or misuse words. Unless race is taken into account, there's no constitutional issue. You can make it as holistic as you want, consider lots of other things. But the only problem is
Can we let, please,
a statement which is race.
sir, please. I think if we could make, it's race conscious. We can all agree on that, and we now disagree beyond that. So I don't think that that's a difference of terminology, but it's just a descriptive matter. Let's let some other people in the audience participate. Please, Manny.
Again, Manny Force. I spoke at the last seminar. The issue I just want to touch on right now is the issue of the test, because one of the arguments is if I score higher than you on a test, then I deserve to be there and you don't. And I think that's a fallacy, because you have to look at who writes the test. Who writes the test? If it's you based on your culture, your values, and your language, and because of the history of this country, I am excluded from that. I don't have those schools. I don't speak that language. I haven't been in that culture. Then I'm not going to do as well on that particular test. Now, on the LSAT, if you wrote about what are the consequences of hitting somebody with an alley apple, all right, or what is the nature of playing the dozens, right? Most people in this room have no idea what that is. They wouldn't do well on that test. If I wrote that test, or if I took that test, I know an alley apple is a brick, because I had experiences in Harlem, in New York. That's what an alley apple is. All right, playing the dozens is an oratory challenge between people on the street, people who think very quickly and speak very eloquently. So the issue of not doing well on a particular test is a fallacy. That's why you consider other factors, and that's all it really is. Is the person capable of doing well in law school based on the totality? That's the point I have to make.
Very quickly, I think that would have been a very telling point 30 years ago, before people started complaining about the content of exams, and before massive reforms were undertaken by the people who compose the exams. You don't see the kind of blatant cultural bias, or even more subtle cultural bias, as you did years ago. And I think if you researched it further, you would come to the same conclusion.
If you go to open public school systems, you would see that. I worked in the open city attorney's office, and I saw that firsthand. So I respect your view, but my experience is more prevalent now, because we exclude people from higher education, higher learning how to speak, learning how to do things of that nature.
If I can just give a brief example of my experience, I applied to law school after I'd lived in this country 4 years. I had lived most of the rest of my life in Mexico, and I was totally unaware of these tests and what you did with them, and I just took the LSAT without any background and got the same grade that one of my friends did. She then realize she needed to get a higher grade, so she had money to go take these classes that got her an increase in 60 points or something. I didn't have that money to take the test again. And if it hadn't been for the University of California at Berkeley looking at my other qualifications and realizing that I could become a good lawyer and ultimately law professor, I would have not gotten into law school. And it's because I didn't have money to go to take one of those classes. That was the sole reason based on if we just look at the test issue. So I just want to make that point because I don't think people realize where the economics come into these test taking. Not only bias based on culture, but also just having money to learn how to take the tests. Another question? Yes.
Actually, I don't have a question, just a quick comment. And I'm on a panel later, so I'm very sensitive about taking more than a minute or two because I'll have my 15 minutes in the sun in the afternoon. My name is Jay Rosner. I run the Princeton Review Foundation. I run those courses, and I've researched the bias in the tests. I could pimp my book, but I can't find it. I have a chapter in a book called SAT Wars, which talks about how all the questions selected for the tests are skewed in favor of whites to an incredible degree. In order to have, and this is my last sentence because, again, I have time later. In order to have an SAT math question appear on the test, it has to be answered correctly by males over females, whites over blacks, and whites over Latinos, to the extent of 97% or more. And it would be hard for me in a soundbite to elaborate further, but I'll make a comment or two more on the panel in the afternoon. Thank you.
Thank you. We are, maybe just one final thought. If you teach constitutional law as I do, this conversation is actually a beautiful thing. And I realize that it often stirs up a lot of discomfort for people, which is understandable. And as I like to say to my students, I think diversity is when you bring your whole self. And so we're doing that in this conversation, and I appreciate that. Society certainly shapes our law, but law also shapes our society. So this conversation is not happening in some state of nature. We are deciding, in fact, what does it mean for everyone to have equal freedom. And so we will continue that, first with some lunch, and then with several more wonderful panels planned for you. Thank you all.